Radio 97, we are talking law with Despina Priala. And if there's anything from the previous 3 years of programs that you've missed, you can stream them right across Christmas and into the new year. You can binge on them. 3 years worth. It'll take you a while, actually. Just go to YouTube and type in Priala, Priala, and all of the programs since 2020 are up there for you to check out. So just go to YouTube and check out Despina's YouTube channel.
Thank you so much, Wayno. And now we are talking wills. So what you should be aware of, Desi, when it comes to these will kits, a bit of DIY, do it yourself. What should we be aware of as the average Joe Blow that want to get a will organised?
Lots of nasty things. So, the do-it-yourself will kit, really, it's still coming up as an issue. And I really think of the do-it-yourself will kit as a black hole and something that you dive into and you just don't know what's going to come out of it. And it's got so many red flags. It's not funny. And we want to talk about why. And I came across another case recently, again in the Queensland Supreme Court, about someone who used a will kit, a template will kit, because will kits are just a templated document. It's not catering for you, who you are, your family, your individual needs. It's just there. And you as a layperson are trying to navigate through a template that you really don't understand the meaning of these clauses and the potential consequences of completing one template clause but then not completing another one, or God forbid leaving something blank. I mean, if you leave something blank, how is someone supposed to interpret that clause? Yeah. So this case recently I came across was another example where someone used a do-it-yourself will kit and thought, well, this is going to be great and easy. And in actual fact, it went off into court, didn't it? Because the person died and then the will came to the forefront. And it was a will that had 11 clauses that were just left blank. And they weren't completed. And one critical clause was, when you gift something to someone, we guide clients through as to, well, what's going to happen if you gift this, this particular bequest to a beneficiary, but they don't actually survive you. So they either die before you die, or they don't actually survive you for the required 30 days by law. And this is what the issue was with this particular case. And it sort of reminded me again that, well, really people, particularly at this time of the year, it is Christmas. We're actually doing a lot of wills for clients leading up to Christmas. I wish it was not just at Christmas, but people seem to think, well, we're leading up to the Christmas holidays, better get that will done, which is fine. But we want to think about these things all year round and not just at Christmas time. But, when you're doing wills, we sit down with clients and we explain to them, okay, if you want to do A, what about B? What if, this person dies, and then what happens to that gift? Because then it's not given to anyone. And in this particular case, what happened is there were 11 template clauses left blank. And one of the clauses, which typically you'll see in a will, that says, if any beneficiary should die at the same time that I die, or die within blank number of days of my death, then they're deemed to have died before me. So the issue why it went to court was, how are they going to interpret this blank number of days? What does that mean? And it went to court, and it was in some ways ridiculous that it had to go to court to try and decipher, well, the fact that the person left it blank, what does that mean? Does it mean that she meant that it's to have 0, nil, or less than 30 days? And the court actually said, well, they should have written in a number at least. And what lay people don't understand, of course, and they're not meant to, is the legislation. And in this particular case, all the states have a usual clause in their succession acts which say that a beneficiary has to survive someone by 30 days. I mean, that's the general rule. So when someone doesn't survive a person that's died by 30 days, right, their estate is not entitled to take that gift. So it has to go to someone else. But if they did survive by 30 days and then they died, then their estate gets the gift. So there is that difference. And, if you don't sit down with a lawyer to talk about these really relevant issues, and they are basic, but if you do it yourself, will kit, and you don't understand that leaving clauses blank can be catastrophic, then you're going to have an incomplete will or a will that's actually classed as invalid, and you actually go through all that trouble for nothing, thinking you've done a really good thing, but in actual fact, you've just created chaos for your family and beneficiaries left behind.
Yep. You talked about 30 days there. Could that person have written, say, 10 days or 5 days or 7.5 days? Or
yes, potentially, yes, because you can write that and it'd be a contrary intention to what the act already provides. So yes, even just by putting 0 or 1 or nil, just something in there for the court to try and work out, well, what did the person mean by this clause? And the fact that it was left blank, and lay people don't understand. If they see a template clause, they don't understand it, they don't complete it. But they don't realize if you leave it in the will, right, and you don't actually cross it out, then that means that it's supposed to apply. But how is it supposed to apply if you leave it blank?
It reminds me of like a grade 12 exam. You're like, oh, no, I don't know, so I'm just going to leave it blank. It's like people so just applying that to their own will, thinking, oh, it will work itself out. Who cares? That's not
exactly
good.
That's exactly right. And another classic example is when you meet couples that are in second or third marriages, and they have children from prior marriages. So often, I mean, we're there to be a prompt to explain to clients, did you think about this or did you think about that? And another classic example is where you have, as I said, a couple that have come together and they're there to see you to do their wills. Now, you might have, say, and I'll use the classic example of the older male and the younger female. Sorry if I've upset anybody, but that's just a classic, typical perhaps couple that rather than an older female and a younger male. So the older male wants to do their will, and the younger one sort of is not really interested because they think they're a bit too young. But the interesting part is that the older male has adult children from a prior marriage. And when the older male comes in and says, look, I'm going to give everything to my lovely new second wife, she gets to inherit everything. So then my question and prompt would be naturally, okay, so what you're really saying is that you trust your new wife to then provide for your adult children after you pass away, presuming you die first. Is that the case? And then they look at you and they say, what do you mean? I said, well, if you give everything to your new wife, and that's lovely, and she's very lovely, that's fine. But what about your adult children? And is she going to provide for them? And then you start to have them think about these issues. And then the end result might be is that he splits his estate, some to his wife and some to his adult children, to make sure he provides for everybody in his family.
Yeah, you can see here, you talk about will kits being, a minefield as it is, just in a general sense. But can you imagine if you're then talking about a second or a third or a fourth marriage, and then all of the children and all the issues and all the property, etc.? You can see how a will kit would be like
a web,
an absolute web. Yeah,
an absolute web. And the other thing that clients benefit from seeing someone like me is that we advise them about, well, who can make claims against your estate. And it's very important for us as lawyers to make sure that clients understand that there are eligible people, Queensland, New South Wales and other states, who can make claims against your estate. You want to take that into consideration when you're doing your will. In particular, which is a very complex area, is your relationship of step-parent, step-child, and the rights of step-children to make claims against the step-parent's estate when the natural parent passes away. So it's an interesting area of law, particularly when everything is given to the surviving spouse and the children miss out in the first instance when their natural parent passes away, and then they wait for the step-parent to pass away. So they can actually make claims, then they have to wait, but potentially there's a claim down the track. But maybe that could have been circumvented or prevented or dealt with in a different way by giving those children something initially by the natural parent. So there's lots of considerations. And in this day and age, there are so many blended families. It's becoming more the norm. And I think that a lot of people just don't think about all the issues that we can prompt them about.
Definitely. Wow. So much to think about now. Thank you so much, Despina. And you'll be back next week for our very last show and then off on Christmas holiday. So if anyone does want to get in touch before we head on break, where should they go?
So they can email info@prialalegal.com.au, give our office a call, 55291 But yes, as you said, next week's our last one, and then we actually close on the 22nd.
Beautiful. Thank you. Of December. Yes, of course. Thank you so much, Despina and Wayne.
And we'll do it all again next week.
See you then, guys.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.